Your Excellency, I'll begin now by reading our statement. We are here for a hearing in the matter of CFI 054-2018 before His Excellency Justice Ali Madhani. The claimant is represented by Denton Zenko. Lead counsel is Rupert Reed QC. The first and second defendants are represented by Ashish Mehta and Associates. Lead counsel is Peter Duckworth. The third defendant is represented by Evershed Sutherland International. Lead counsel is Thomas Pluman QC.
Would you repeat the name of the third defendant's QC? Thomas what? I couldn't hear you.
Thomas QC, Pluman QC.
Thomas Cuman?
My lord, it's Pluman, P for Peter, L-E-W-A-N.
Right. Mehta, can I have this, the list of representations sent me by email?
Yes, sure, I'll do that now.
Yes, Mr. Reid?
My lord, this is a CMC of claims by SBM against what I shall call the third defendant, that's to say Prime. It is in effect the only defendant.
So far.
Because SBM and Prime are the active parties in this litigation. As between SPM and Prime, there's not much between them. You will have seen, my lord, the draft case management orders. There's substantial agreement that we need to know the position of the first and second defendant. I'll refer to them actually as Renish collectively, just for convenience. But we need to know the position of Renish going forward, and we both seek a debarring order so that if they don't confirm whether or not they are making an application to set aside the immediate judgment within 7 days, by the 19th of February, they should be debarred from making such an application.
What's the basis of 7 days? Why particularly 7 days?
Well, my lord, there's no.
Where the numbers come from?
There's no magic. There's no magic in 7 days. We simply say that they have known of these proceedings since September or October last year. You will have seen the evidence in the contempt application, the committal application in December, where they essentially said we're thinking about it. We haven't yet got any funding. The absence of funding, I should say, seemed to be no obstacle to their launching a very extensive appeal with a 70-page appellant's notices. And they essentially said they were keeping their options open. Now, my lord, as we seek to advance this litigation, that position is simply intolerable. They have had since October last year, even on their own evidence as to when they discovered the existence of this litigation. Mm-hmm. And this court now needs to make directions through to trial. And it would be intolerable if Renish were able to sit on the sidelines and threaten an application to set aside immediate judgment, which could have an extremely disruptive effect to any directions that your lordship is being asked to make in respect of the main trial, the trial between the active parties, that's SBM and Prime. And that's why, my lord, we do seek the discipline of a disbarring order. We entirely accept what Mr. Duckworth says about it being exceptional circumstances for such an order. But we say these are exceptional circumstances. And we would add to that the fact that Renish is in continuing contempt. Your lordship will be aware of the background. Your lordship heard the committal application in January last month and saw the evidence in that. There's no suggestion that they have any intention of complying with any orders this court gives. Even if a cost order is made against them, they are signalling fairly strongly.
I see the ground you say putting, Mr. Reid, is against the idea they should even apply for set aside. I understand. My question was only why the 7 days. We're talking about extending the timetable of this case. We've even abridging maybe summer. We're looking maybe at July, August, maybe September, for the trial. Well, I said, why we're in a hurry? Why we don't just give them 2 weeks or 3 weeks maybe to apply or to revise it? Maybe they want to do some attempt. Maybe they want to come with, let's say, proposal that doing something before they even apply.
My lord, I'm not going to strongly oppose 14 days or even 21 days if your lordship is so-minded. I can see the merits of that. But what I am going to say very strongly is that we need to know the position. And and insofar as Renish claimed that there shouldn't be a debarring order, what it is essentially trying to do is reserve to itself the ability at any later time to decide that it wishes to make an application to set aside immediate judgment. Now, your lordship will be aware that where there's an appeal, there's a very tight period of time, 28 days, in which to serve an appeal notice. And that's because parties require finality as to what the situation is. The requirement for finality is even stronger in this case, where there is ongoing litigation, which any re-entry, if I can call it that, by Renish would need to fit. But although there is no formal time limit in respect of an application to set aside, we are now in a position where the immediate judgment was given in September of last year. We are now 4 months on, and we are still having a set-aside application insinuated or suggested. It's perhaps worth just looking at what the position is said to be on the evidence of Renish. If I could take you very quickly, my lord, in the bundle to page IA 900. Does your lordship have it?
Yes.
That's the witness statement of Miss Vedaduta Nag. And then if I could take you to paragraph 21.
No, give me the reference again, the page number, please.
Page IA 900.
HIA. Is this the reference on the page? Don't give me the full reference for the file and the tag, and then just give me the number showing on the page. Like there is single letter and then the number of the pages.
Just let me find that for you. I have IA tab 17.
Mm-hmm.
And then page 900.
Yeah, what paragraph you're referring to?
Referring to paragraph 21, my lord.
Yeah, the bottom of the page.
That's right, yes.
Right, I'm there.
Contrary to the impression they have given in the main proceedings, it is the applicant's wish, albeit belated, to engage fully with these proceedings, and they apologise for not having done so to date for the reasons previously set out. Further, I'm instructed that they wish, if possible, to reach an amicable settlement with all creditors subject to availability of sufficient financial resources. In pursuit of these objectives, the applicants have instructed AMA to go on the record and have arranged third-party funding. They wish to defend the main proceedings and intend, as soon as practicable, to file an application to set aside or vary the immediate judgment of 27 September 2020 pursuant to RDC 2422. By as soon as practicable, I mean that AMA will file the application when they've had an opportunity of taking full instructions and assembling all relevant paperwork. At this juncture, it's not possible to predict precisely when that may be. But I believe that setting a date for the committal application sometime in or after April 2021 should allow an adequate window of opportunity. So essentially what they want is the leisure to decide when it's practicable whether they wish to set aside a final judgment of this court rendered in September of last year. A judgment, I should say, which was delivered in emphatic terms as to an inference based on a significant number of factors. And your lordship, in dismissing the application for permission to appeal, will have reviewed not only the judgment, but all of the various bases on which the inference is drawn. And essentially, it is a stool with 7 legs in terms of the numerous factors and the very strong inferences which your lordship identified in the immediate judgment. And we say further that that in any event this application is hopeless because there is a very either there was a fraud, or even on Renish's case, that these were genuine contracts. We are perfectly entitled to enforce our contractual rights, both as against Renish under the contract and its promissory notes, so there are 2 contractual bases, and as against Mr. Mehta on the basis of personal guarantees. Now, you will have seen from Mr. Duckworth's skeleton arguments that various attempts are made to suggest that there might be. I think it said that the bank's debt claim looks strong. Well, in our submission, it looks far more than strong. The only suggested defence that could possibly be raised is one of a fear of double recovery. Well, double recovery is an issue of enforcement. It's not an issue as to liability, but there are often cases where there is joint liability, joint and several liability of defendants. The finding of liability isn't disturbed by the rule against double recovery. At the level of enforcement after judgment, clearly you can't enforce against all of the defendants who are found to have been jointly and severally liable. So that's not an issue that poses a defence to a contractual claim. And then it is said, well, there are sums that have already been recovered. Well, that's right. If one looked at the immediate judgment and the skeleton to the immediate judgment, there is a schedule of the monies owed. And to the extent that monies have been recovered from another SBM account, and there was about $3 million, $3,090,217 recovered, a full account for that amount has been given in the tables by which we computed the amount, and the court computed the amount of the immediate judgment. So there is no defence in respect of an amount for which account has already been given. And as for the residue in the prime accounts, you'll remember these are the accounts to which the SBM loan monies were advanced and then very rapidly drained. The only sums left in those drained accounts were the sum of 1,113 dirham and 31 fils and $184.54. So tiny amounts for which we would obviously give credit. So there is no defence to a contractual claim. There is no basis on which we could, or which the Renish could set aside the immediate judgment. And I would add to the fact of the evidence that is put before the court on that occasion, and that is fully canvassed in the immediate judgment, the fact that we now know quite a lot about the payments out of the prime account. And if I could take you very briefly, my lord, to bundle G, page 201. And sorry, it's bundle G, tab 14, if your lordship's using tab.
Yes.
And there you have it's a request for further information, but it's a useful summary or reference to the ongoing work that's taking place in respect of the flows of funds. And if I could take your lordship to page G201, yes, that's, does your lordship have that?
Yes, I do.
And if I could take about halfway down that page, you'll see a heading under, and then particulars, third payment defence, third cargo. And your lordship will remember that there are essentially 6 cargoes and 6 payments in issue here, and that this is dealing with one of them. So if I could read from the top, on the 23rd of May, Prime received $13.7 million US dollars from SBM. So that's a payment of trade finance that's made.
Right.
And so then request 26, Prime made 2 transfers to Petrohub Well, Petrohub is a prime, is a Renish subsidiary. And then going down to request 30, Prime transferred $2.8 million to its AED account, its dirham account. You remember these are round number payments out of the account. And out of that AED account with MBK, there were then a number of further onward payments. So A is to Neon. We understand Neon to be a Renish subsidiary. And then if we go down to C, 302,000 dirham was paid to Petrohub. That is another Renish subsidiary. And then at request 31, on the 23rd of May, Prime made 2 transfers to Renish for $5.6 million and $1.5 million. Again, round figure sums being paid out to Renish or Renish subsidiaries. So the question posed by Mr. Duckworth, cui bono, i.e. who benefits from this fraud, is strongly answered on the further evidence further to your Lordship's immediate judgment that suggests that Renish was a significant beneficiary of the trade finance fraud that were paid through the Prime account with NBK, paid on into other accounts, and ultimately, on our case, were then divided up between Prime.
Well, I think, Mr. Reid, I think you just went a bit further. Well, as I said, I'm aware of this. It's a real fact. It's not a time where I think you should bring this all to my attention now, and maybe we didn't need even to check whether Renish and Mr. Mehta wants to defend against this information at this application. I think we have another business to do today. But I can see your point why you would oppose
my Lord, I'm in your hands, and I would certainly emphatically agree that this CMC should not be a pre-hearing of any application that has been intimated by Renish.
In summary, I really see your note. They should not allow. If they allow, they should need given a strict time to apply, and even in that application, the court must be reminded with the all founded ground against them, and on the basis that there is no ground for allowing them to set aside the immediate judgment by any means. But I understand your point.
You have my point.
Yes. And I want to know, there were in your skeleton argument, there is a 2 point in which D1, D2, Renish and Mr. Mehta should be allowed to hear this CMC. And that was, what is the 2 central point that they should allow to present at this CMC?
We accept that they should be entitled to be heard on the issue of whether a debarring order should be made against them.
I see.
And also we accept that if they intimate a desire to come back, as between myself and Mr. Blumen in seeking to construct a sensible timetable, or propose to the court a sensible timetable to trial, in my submission, we should seek a timetable that accommodates the possibility, and the mere possibility of their coming back, of their making an application, and of your Lordship granting that application. In fact, matters have moved on, my Lord, and I can say that both the claimant and the third defendant have agreed that they have availability of all of the relevant witnesses, all of the relevant lawyers in a fortnight in October. That's the first fortnight from Sunday the 3rd of October. So there is, with your Lordship's, if your Lordship was so minded, there is a window naturally available, which makes sense in terms of expert evidence being prepared and discussed and jointly reported upon over the course of the summer. But also, if Renish and Mr. Were to come back into the action in their own terms, such a trial date would accommodate that. We do.
Well, Mr. Reid, I think I've been thinking about this exactly the point. I mean, the engagement of an expert between you and Prime, because we want to check Prime's records in terms of this transactions. But now we have Renish, Mr. Mehta, come to the record, and They are involved substantially. They are the center of this contract or of fraud or whatever you want to call it. The expert wants just work in favor of whether checking the it's investigating the defense in favor of Ibrahim. But as long as Renish is there, the expert could provide us a better understanding of the case, of the money flow, of the transaction, of the nature of the relation between Ibrahim and Renish from both sides. That's what I thought. If you bringing this case and based in a fraud, and then we have two defendants, and now throwing the blame on each other now. I would think it's very sensible that
well, of course,
the expert in a better position, I mean, to have deal with both parties, Ibrahim and Renish, check both records, and I don't know from your side as well. I mean, you're a central party to this proceeding, so. Because see, at the end of the day, we are a truth finder. We need to know what's the truth. Is that true, Mr. Reid? We need to know what is behind this. What's wrong? What was right? You need to prove the fraud. You need to prove. Maybe it's easy for you because you have already proved the transfer of your money, and then someone has to pay it back. Mainly Renish, yes, and we understand. And then we're going to find a way how to involve Ibrahim as whether having dealt with this in a fraudulent basis along with Renish or not.
Well, my lord, I'd say three things to that. But firstly, there is no purpose in terms of Renish's liability of any involvement in the trial. On any analysis, Renish and Mr. Mehta are liable in the full amount as a matter of contract, whether performing the contract, paying back, whether paying damages, whether paying on the promissory notes, and in the case of Mr. Mehta, on his personal guarantee. So the end position in respect to D1 and D2 is entirely predictable. All we say that will be added by throwing D1, allowing them to re-engage with the action, is that there will be a significant lengthening of the trial timetable, which will be to the detriment of the real participants, that's to say SBM and D3. And we will possibly then go from a trial of which in our view is 5 to 7 days, something potentially significantly longer than that. Inevitably, because one has additional experts, each witness is cross-examined not by one party but by two parties, so a very significant increase in the costs and the time of trial. And I should say that whilst it's beguiling to think that D1 and D2 may comment on the fraud, their case is that there is no fraud. Everything was a genuinely honest transaction, and it was Prime that simply failed to deliver the cargoes. Now, so all of a sudden, Prime is contracted to deliver the cargoes to Lanka in Sri Lanka. It fails to do so. This overnight shuts down Renish's flourishing operations. Mr. Mehta suddenly has to cease liaising or corresponding with anyone. He has to abscond immediately to India, having closed down everything in Dubai, and he has to. And you then have and he then significantly benefits from all of the payments out of the Prime account of the monies that were advanced by way of trade finance. Now, it may be gratifying to cross-examine, for example, Mr. Mehta on how on earth he thinks that story has any plausibility, i.e., I was let down by my counterparty, Prime. And as a result of that, I immediately had to close my operations. I had to run for India, and I had to grab the cash that had been paid through the Prime account into my various subsidiaries and into Prime.
When I see this, and I can add to this, while having the most of the account was transferred to his subsidiaries and branches as well. I mean, not even all of it to the Prime. But I understand all of this background. I know what. Yes. And what position they are up to date. I mean.
So whilst I would no doubt enjoy the cross-examination, and Mr. Pluman may likewise, And whilst it may be a more perfect inquiry as to the truth, this court is not conducting a judicial inquiry. It is examining claims made in respect of liability. The claims made against Renish and Mr. Mehta are entirely clear. There is no defence to those claims, and we are entitled to judgment as against Renish and Mr. Mehta. And we are entitled, and Prime is entitled, to as speedy and as cost-effective trial as possible on the remaining claims against Prime. As I don't think I need to take your lordship through all of the indicia.
No, I want you to tell me what's the consequence of the court, for instance, allowing a set aside of the immediate judgment against Renish and Mehta. What is the consequences? How you would, what kind of scenario you would imagine, Mr. Reid?
Well, the consequences is they would then come back into the action. We would then have we'd have an additional expert on behalf of D1, D2 if their funder so permitted. We would have a much longer trial. We would have doubtful an issue as to assuming that we get our costs as against the claimant recovers its costs as against Renish and Mr. Mehta. These are parties that have not complied. They have thumbed their nose at this court's orders since 2018. We say it's quite, insofar as Prime says that it didn't receive emails, it can point to a particular error. It can allege that it didn't have control over a relevant email account. Mm-hmm. But as for Renish, you will have seen from the original freezing order that your lordship made, there was a number of Renish email addresses, various Renish personnel, all of whom were received emails. And the only explanation for that is that when Mr. Mehta had to close down his flourishing business operation in an extraordinary hurry around the 12th of July 2018, all of the computing systems, all of the offices were lost, and he lost all of his records, he lost all of his documents, and he lost all of his computers, and all of his relevant email accounts were lost. So that is the basis on which he says he didn't learn of the order and the claim in 2018. Well, that, my lord, makes no sense to us. So this is a party that has been in flagrant contempt of court since 2018, on its own evidence since 2020. And what we would then be faced with is a massive trial, essentially a judicial inquiry into this fraud, which is unnecessary in the case of Renish and Mr. Mehta, because they are plainly, on multiple bases, liable for the full amount of the losses of SBM, and all we would be doing is ramping up the costs and the time of the trial.
So what's their position now? What's your position? Understand you put it before them. I mean, it was said to them that the ideal way is to deal with this is to set aside instead of an appeal. What's their position now, and what's their position with it? Are they really intending to bring that kind of application? And if they are, wants to bring that kind of application, in what time frame? Because I couldn't anticipate that. They need to apply, other party need to respond, the court need to deal with it. They might have another right of appeal. This would be, I mean, from this basis, I mean, even if they want to catch up with the CMC up to the trial timetable, I would agree with you. They need to act promptly, maybe yesterday. But can we pause here and ask Mr. Blumen if he can assist? I mean, just to give us a clue in what are they thinking about bringing set-aside application and what time frame? And then we continue the discussion, Mr. Reid. Are you okay with that?
I think Mr. Duckworth is acting for D1, D2.
Oh, Mr. Duckworth, I'm sorry, yeah.
Yes, if I may assist. The set-aside application is in draft already. It requires considerable checking, both by me and by my instructing solicitors, and we are not ready at this point to serve it. But it is anticipated that within 21 or preferably 28 days, but let us say there or thereabouts, we shall indeed be serving the set-aside application. And therefore, with all due respect to Mr. Reid, his comments about us holding the parties to ransom for the rest of the summer are simply inappropriate. We've offered a 21-day slot, and if we don't fulfill that, then the claimant has its remedies in default. But what we say is it would be wrong to write the unless order in those terms here and now. But I hope that assists with some idea of when we intend to come into the proceedings.
For initially, I think, Mr. Duckworth, this is a further dragging time. I mean, to bring a set-aside application, because and if you bring it within 28 days, and then you will give the parties, I mean, time to respond to it. That's at least a minimum of 2 weeks, and then you would need another maybe 2 weeks for the trial time to set up, and then another 2 weeks, maybe the maximum that the court can deliver, 10 days to 2 weeks to deliver judgment. And this is before even that you have a time for permission to appeal, and this is an automatic 3 months timetable, as I can see.
And my lord, if there's no guillotine, if there's no debarring order, what Mr. Duckworth is essentially proposing is you should have 28 days, and then if he doesn't do anything within those terms, we would then have to make an application
to enter judgment against them
for an unless order at that stage. That application would no doubt have evidence, responsive evidence, reply evidence, and that's before you even get to a set-aside and a set-aside application being heard. So if he then makes a set-aside application before the unless order application on his scenario is heard and determined, you're probably adding another 6 weeks to that timetable, and that's why it's critical, we say, that the debarring order be made now. I'm less pressured, I'm less worried about the precise amount of time. If Mr. Duckworth says he needs 14 days, 21 days, then I think those instructing me would be relatively relaxed about that. But we do need some discipline imposed in this order. We do need a sensible period of time. And in our submission, where they've already had since September to read and review the immediate judgment, they've had months already. They have not, they're still in contempt. This is not a party that deserves any significant indulgence from the court, and in those circumstances, we say it should be a limited period of time, and there should be a debarring order at the.
What's the reasonable time you think, Mr. Reid, if an unless order is to be given? I think 14 days, 20 days, what the maximum?
Well, as I say, we've asked for 7. I accept that is tight. 14 days in my submission would be entirely reasonable.
Mr. Duckworth, would 14 days would be sufficient for you to submit your application?
Well, my lord, it probably would in ordinary circumstances, but I draw the court's attention to the fact that only yesterday important documents that founded the application for immediate judgment and separately the application for committal were disclosed for the first time to the first and second defendants. These are the NBK bank statements that are crucial to your lordship's immediate judgment and crucial to any finding of contempt. You will recall that the freezing order in 2018 required my clients to account for transactions out of the NBK account. That was, of course, intolerable if they had never seen the statements. We've made this point several times, and very late in the day, the 11th hour, Denton's, on behalf of the claimant, supplied those statements to us yesterday afternoon. It's going to take some time to analyze those statements, take instructions, and go through them. So whilst I would ordinarily not be strongly opposed to 14 days, this new factor requires careful consideration of our position. And so I would respectfully submit that a 28-day timetable is reasonable.
My lord, just on that, we draw attention to the fact that in fact, Renish are a signatory to the NBK Prime account. They have had access to this financial information at all relevant times. We were not required to disclose it. We have voluntarily disclosed it because we didn't want to see a bad point being taken as the basis of a set-aside application. We've now disclosed it. The financial analysis of the payments through and out of the Prime account can be reduced to a spreadsheet of 7 or 8 pages. There's nothing especially complicated. The effect of it is that the monies were paid through the Prime account to Petromaster, a Prime subsidiary and Prime, and to Renish subsidiaries, a number of Renish subsidiaries, and to Renish. Now, I realise that my friend may feel slightly tripped up having asked cui bono, who benefits in his skeleton argument. But the reality is there is absolutely nothing for D1 or D2 in those statements. They've had access to the financial information all along. It should not take a significant amount of time to decide whether they wish to make a set-aside application, not least since they've had their judgment.
Well, I think I agree with you, Mr. Reid. They should know more about their account, more than the bank himself, I guess. I mean, let me ask Mr. Blumen if 21 days as maximum would be reasonable for Mr. Duckworth to bring up his application.
Lord, insofar as you're asking me representing Prime. Prime is, of course, would not directly be a respondent in the set-aside application itself, because that's an application back against the claimant. But our interest in this relates to the trial date. Prime is under the burden of a very onerous worldwide freezing order, cannot conduct business, and is desperate to get this matter into trial as soon as possible. And frankly, we don't understand how, when the immediate judgment was given at the end of September, we can be sitting here in February with Renish still saying, well, it hasn't considered what it needs to consider. It needs to get on with it. So we're entirely in your lordship's hands. But our position is that the trial should come back to court as soon as possible, and the set-aside application should have to be brought quickly, if it is to be brought at all, and dealt with so that the trial is not further adjourned.
I see. That will not leave you with a lot of difficulties, Mr. Duckworth, to decide your time. Your time is given. I would accept that. You have 14 days, 2 weeks, to bring that application in whatever ground you wish to bring it. And that would be, again, in an unless order form. So you better work from yesterday, Mr. Duckworth.
Yes, thank you, my lord. Yes.
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 That's fine. Mr. Reid, let's go to the other items of the CMC for today.
Well, my lord, related to the debarring order is whether there be directions provided on a conditional basis, i.e., if a set-aside application is made and granted, then these directions apply. If it's not, then those directions apply. I start by saying that Renish wanted a 2-step process by which the claimant whether it would contest. I can give that confirmation now, so there's no need for any such 2-step process. In terms of conditional directions, D3 Prime in its skeleton suggested in very broad terms a timetable. That timetable doesn't work in that it gets to the end of disclosure by some date in May, the 21st of May 2021, and then witness statements were proposed on the 13th of May. So there's a slight hiccup in terms of the end. There are problems with the proposed conditional timetable proposed by Prime. It is slightly foot to the floor. For example, it would require a court determination of any set-aside application within 14 days. So it requires everyone to be
that's not realistic now.
Fully focused, and there's an element of unrealism in that. It also, as I've suggested, requires witness statements before the disclosure process is finished, and it would make no provision for expert evidence on the part of the first and the second defendants. So they would have to join. Assuming they came back in, assuming they were allowed to come back in, they would need to join the expert process. And obviously within experts, one has reports, responsive reports, meetings and joint reports. So there would need to be time for that. And in our submission, the these problems are unnecessary for two reasons. Firstly, we don't know whether Renish, if it applied, would be allowed back. We've made a very, hopefully, we believe there's a strong case that it would not. So we don't need to be making conditional or contingent directions based on an assumption, which is unlikely that they would come back in. And secondly, as I said, those instructing myself and Mr. Fluman were exchanging dates to avoid, and it became quite a complex spreadsheet in terms of dates that various witnesses, experts, and counsel could do. But there is a period, the first fortnight in October, when both legal teams, both sets of experts, both sets of witnesses would be available. Now, if the court were able to list the trial in that window, then that should put no particular pressure on the timetable if the court ultimately decided that Renish should be allowed back into the action. So in those circumstances, my lord, we say it's unnecessary to make conditional directions based on an assumption that Renish may be allowed back in. The only other issue which you'll see canvassed in the skeleton relates to account evidence. And your lordship, remember there was an issue in the CMC in September as to whether there should be permission. Essentially, it was said by Mr. Page on behalf of Prime that they wanted to rebuild the audit trail in terms of rebuilding the ledger that existed between Prime and Renish. Your lordship decided that it was premature and that the issue needed to await disclosure, and that was the order made in your lordship's case management order, that there should be permission to apply or leave to apply for permission effectively. What then happened was that the reconstruction exercise is essentially reported upon in Mr. Sadder's witness statement, which was served on the 7th. And that was why the trial had to be adjourned, because there was a huge amount of work, and very expert work, we say, that it was involved in the reconstruction of the ledger, the reworking of the audit trail of all of the transactions, involving not only those parties, but a lot of third parties, the producers of the oil in Iran, various converters in Iran who were intermediaries, if you like, and the end purchasers, including Lanka. And for those reasons, we said, we recognized fairly quickly on reading Mr. Sadder's statement that we needed expert evidence to probe, to consider that reconstruction, and also the expert points which we say are made by Mr. Sadder along the lines of, well, if this was a fraud by Renish, you ought to have spotted it. Because there were various red flags in the forged Renish documents, for example, as to the payment terms or other terms. So, and I should say it's pretty plain when one reads Mr. Sadder's statement and his references to this being a very costly job, hundreds of hours being involved, and the assistance of various agents, that actually Mr. Sadder was significantly assisted by the accountants for whom Mr. Page has sought permission back in September. So we accepted at that point that expert evidence was necessary. If there were no such evidence, then the trial judge would essentially have to either accept the ledger as reconstructed by Mr. Sadder, or would have to probe himself or herself by looking at the underlying documents, which would be an unenviable task. There was a little bit of a discussion, an issue as to the scope of the expert evidence, whether they should be able to consider the relationship between Renish Prime and third parties. I think it's now broadly accepted that they should be able to, the accountants should be able to look at those relationships with third parties, but with a focus on the ledger and a focus on essentially how the ledger is reconstructed by references to those transactions and those payments with third parties. So there is sufficient focus. There was a concern on the part of Prime that we might be trying to use an expert to cast aspersions on the general nature of Prime's business. Well, that's not the purpose of the expert. There will be plenty of other bases for doing that. That isn't the function of the expert. The scope has been clarified. I don't know if your lordship has seen, there's at the back of the correspondence in the bundle, at page IB 63,
Where can I find that? What page is that?
It's IB 63. It's right at the end of the bundle. It's almost 20 pages, just about 20 pages before the very end of the bundle.
Yes. You said 73 or 63?
63.
63. Yes, the issue of expert evidence.
Now you'll see this letter rehearses previous proposals, and then about halfway down the page is a paragraph beginning for the reasons explained.
Yes.
And below that is a quotation. That's the agreed scope of the expert evidence. So that's the expert issue, if you like, as by the claimant and the third defendant is agreed by those parties. So, my lord, we require the permission of the court under RDC 3112. We say that such expertise is necessary to assist the court, and that is the expert issue that has been agreed as between the active parties.
Well, initially I didn't have problem with this, but let's suppose that the Renish case, progress further, and I don't know, someone would say they might have to take a part in these things, and how we can then accommodate the Renish existing the proceeding. I'm not saying they're going to win the case, but even if it's 1%.
My lord, we say the Renish are not a party. They have a final judgment against them, permission to appeal denied. Yes. This comes to my conditional directions point. In my submission, we can't be making directions now on the basis that Renish has some interest or some entitlement or standing to dictate or require particular directions. If having been made, if it makes an application, if it succeeds in that application, which we say is extremely unlikely in view of the very strong claims against it on any basis, then if it requires additional expertise or permission, then it is of course open, it would be open in those circumstances for Renish to apply. But the issue for an accountant are going to be the ledger and the cash flows as shown on the relevant financial documentation.
If I understand this correctly, so the work of the expert is to investigate the prime defense and its relation with Renish in this transactions, and that's all we need. And this is all about the involvement of a prime in what's so-called a fraudulent transaction along with Renish. So this is like it's either an evidence against prime or the only prime evidence, and to get out of that conspiracy. And this should not affect Renish position, because they, as you say, they're responsible for the money to be paid back, whether on contract basis, fraud basis, or any other basis. Is this the basis? And I should understand it. Yeah.
Prime says it was in an ordinary trading relationship with, or quite a complex with Renish. It received monies from Renish, and it believed them to be part of that ordinary trading relationship. Now, in our submission, when you start to unpick the transactions and the timing of the transaction, the amounts, the suggestion that Prime had an innocent understanding of the sums that it was receiving into the Prime account falls apart. But that's its position, and it seeks in its reconstruction of the ledger to justify its allegedly reasonable understanding that these were normal commercial payments. And you're right, it goes to the heart of Prime's defence and our claims as against Prime.
And that shall not affect the position of Renish, isn't it? Whether Prime is innocent party or not, Renish is still responsible for the whole.
My lord, yes.
Amount. If they want to engage Prime, that's their case. Yeah, I see. And this would be even let's say, a ground for a Prime to defeat the Renish allegation against Prime itself, isn't it? So it's the same. It would work like two sides. It's with the relation between Prime and Renish would help both Prime in its position in the case and Prime position against the allegation brought by Renish. So you didn't think that we will need to amend this the scope of the expertise in here, sir? Is that right?
I can see no reason why Renish would want to would seek any further permission or any expert accountant's evidence beyond the scope of this existing issue that's agreed between SBM.
Yeah, I just want to make sure that we're thinking in the same law.
My Lord, might it be helpful for me to explain Prime's position on that? Or it may be helpful for your Lordship to understand what the Prime case is. So the Prime case is that it had a relationship with Renish, which involved payments being made both by Renish to it and by it to Renish in order to be paid to other parties. And at the same time, it was selling oil to Renish, which Renish in turn was supplying to other parties. And all of that gave rise to what it calls this ledger. And it may help for me just to show it to your Lordship. And it's an exhibit to Mr. Saylor's witness statement. And if your Lordship were to go to bundle IA, page 1077,
IA, what tab, excuse me, Mr. Lisman?
I'll give you the tab in a moment. So it's bundle IA, and the tab is, Lordship, just give me 1 minute. The tab 24.
Right.
Which is page 1076, in fact, is the cover sheet.
Yes, I'm in there, yes.
You'll see it's exhibit 2 to the second witness statement of Ali Sader. You have that?
Yes.
And if you turn down to the next page, my Lord, you'll see the first of some 10 or so pages of exhibit which deal with the transactions between Prime and Renish in the first 6 months of 2018. And as you'll see, you get debits and credits, payments backwards and forwards, all of which go to the balance between them. And if you then go down, if you would, please, to page 1082.
Yes.
And if you look at the dates in the second column from the right, and about 3/4 of the way down the page, you'll find a date which is the 19th of March, 2018, received from Renish, and then something's gone wrong with the typing, but it's in regard to a fuel oil project. And the credit, as you can see further to the left, is 38.3 million dirham. Did your Lordship see that?
No, to the 19th of March, I can see 78 million, 66 million, and 49 million.
So if you're on page 1082.
Oh, you said 38333?
Yes.
Oh, the credit. You want me to look at the credit or not the balance, huh? Okay. So
That is the first of the payments, the 4 payments which this case concerns, from Renish to Prime, which Renish in turn had obtained financing from SBM. This is the first of them. And so you can see it comes into the relationship between Prime and Renish as part of a whole complex of payments inward and outward. And if you were to go down again to page 1085,
yes.
About 1/3 of the way down the page, 25th of May 2018, you'll see dollars received from Renish, 8.844625 against sale of 37.9 million tons, 1,000 tons of fuel oil. Credit 38.459 million dirham. That is the second of the payments. And similarly, one will find the third and the fourth. And I could take you to those. But what you also are having at the same time is payments going backwards and forwards arising out of their relationship. Now, the expert issue relates to the verification, in effect, of this reconstructed ledger between Prime and Renish. The original was held by Renish and seems to have disappeared, so it's been reconstructed, and the agreed expert evidence would go to verify that this process has been properly undertaken. My learned friend, it says it's been compiled already with the benefit of expert assistance. There's no basis for that. It's been compiled on a factual basis, but what he is right about is that it is a complex schedule with lots and lots and lots of documents that underpin all of the entries on the ledger, and all of which have been disclosed. So that's what the forensic accountants will verify. Now, if Renish were to have a case about all of this, so if they were to have something to say about all of this, the issue would be identical. It would still be the issue of the reconstruction of this ledger. So there is no reason to believe, and we would support in that sense what Mr. Reid said, that if Renish do succeed in a set-aside application and come back into the case, that they will need expert evidence of a different kind.
I see you, Bon. Thank you, Mr. Bloomman.
Just while I'm speaking, Lord, so far as the question of conditional directions is concerned, it may be appropriate for me to say it's not that we suggest conditional directions, it's that we suggest that Renish shouldn't wait while a set-aside application is brought and litigated and ultimately decided. It should have to prepare its defense, begin the process of disclosure, begin preparing its witness statements, all as if on the assumption that it might succeed. And it's true that it will waste some expense in doing so, but that is the price of it seeking to join this party so late in the day. Because the one thing that is fundamental is that the trial dates, if it is to be October, or we had wanted June or July, but if it is to be October, the trial date cannot be pushed further up.
Well, I'm very pleased really to hear this from you, Mr. Bluesman. I'm saying things. I mean, I agree. It's a very positive statement, Mr. Duckworth. You really should be looking forward, like an act from today, as if you in a position to win that application, and you'll be ready to catch up the train. You'll be ready to exchange evidence, to present evidence, I mean, you need to talk to your witnesses, to have something in writing, to catch the train very, very quickly. That is a very forward thinking by Mr. Bluman, and which I really encourage you to do so.
Hey, may I come back on that then?
Yes, you should.
Thank you so much. With due respect to Mr. Bluman, it's putting the cart before the horse, because until we know for sure that we're back in the case, we're going to incur a lot of unnecessary costs, all for no purpose. Mr. Reid is to be believed. We don't have a chance of coming back into the case anyway. But yet Mr. Bluman says we have to go ahead and prepare witness statements and pleadings and all that kind of thing, and participate in expert reports. That really shows the flaws in the thinking.
Well, no, Mr. Duckworth, if you didn't believe you're going to win that application, you should not bring it at all. That's what I'm going to say to you. If you didn't have a belief that you have a very strong basis for your application, if you didn't think you have a winning document in your hand, you should not run for that race. It's just an extra cost for you, for your client. And that, I think, that's the basis. You should even advise yourself, advise us, and advise your client. If you're not running a strong case, you know, I mean, you need to evaluate your position. You know your position. Yes. You need to advise yourself and your client the best approach in dealing with this case. It could be something else. It could be this application. It could be the solution might be not to go for this application, but to go for something else. I mean, that is my advice. I would still think what Mr. Blumen has said is completely right, because you need to go with that good vision about your case, about what's the point of taking, I mean, unrealistic approach. If you were to follow Mr. Reed, I mean, assessment to your application, then you failed from now.
My Lord, of course we believe in our case, and we have strong reasons to do so. And I accept that, of course, we will present our set-aside application with conviction, or else we won't do it at all. But having said that, we are also convinced that the immediate judgment was obtained on a false basis, and I don't refer necessarily to the debt claim, which was well-founded, but I refer to the claims of fraud, which were a very shaky basis on which to obtain judgment. And on
what difference it make, Mr. Duckworth? What difference it make? You need to think, what's the big difference? What's the big margin from you being accountable for repaying all of this money, and in what basis? I mean, you need to have a very good, clear strategy in how you're going to clear this debt. The point is, what you going to pay to court at the end of the day?
Lord, of course, we accept that. I don't concur with Mr. Reed's submission that we have no defence to the debt, but let's put that to one side. Let's say that we're primarily liable for the debt. Nevertheless, my clients have an active interest in clearing their name from fraud, because they have been found to be guilty of fraudulent conspiracy, which has very serious implications for the future of Renish's business, or Mr. Mehta's business. He needs to clear his name, and to do so, he needs to set aside the findings that were in the immediate judgment, even if he doesn't succeed on the debt claim. So we have every interest in coming back into the proceedings for that purpose, if none other. And that's why I have invited my learned friend, Mr. Reed, on behalf of his clients, to concede that the immediate judgment should be set aside in that regard, and that we can therefore defend with a clean sheet. We can come into the case and participate in every step, including expert evidence, as needs to happen. Then Mr. Pluman can be satisfied that there's no risk of adjourning the trial. He's got us firmly locked into the case. We have to comply with all of those time limits. The anomaly in this situation is that the claimant is hanging on to an immediate judgment which is defective. It's flawed for a variety of reasons that I can enlarge upon quite readily.
Well, no, I think you better do it in the right time later on, Mr. Duckworth,
Yeah.
During your application.
My Lord, yes, we don't wish to pre-argue the application. You've seen the terms of the immediate judgment. In our submission, the Renish's strategy is entirely cynical. It clearly knew the order back in 2018. It was emailed to a number of Renish email addresses. Mr. Mehta,
Well, Mr. Reed, we can't deny them the application itself. I mean, they have that right. We all know that, but
it will be strongly resisted. The immediate judgment is right. Only after the immediate judgment order was made did Renish and Mr. Mehta.
That's subject of a trial. Then,
having apparently conducted a Google search, this is part of the continuing strategy. They have no intention of paying. Wish to leverage whatever position they think they have. Opposition opposing the immediate judgment.
So what's left for us to discuss?
Well, my Lord, I wonder if we, at this stage, we look at the draft order that was attached to my skeleton, the claimant's skeleton argument, and we may be able to draw together some of the threads.
We should start with the trial date, in my opinion. And
my Lord, do you have my skeleton to hand? I don't know if you printed it all.
No, I do. It's with me. Yes. He wants to refer me to the draft order toward the end of your skeleton argument.
My Lord, yes.
Yeah.
Does your Lordship have it?
Yes, I do. I'm there. Yes.
Well, my Lord, paragraph 1 is the time required for making any application. I think your Lordship's granted an additional 7 days, so I think we're now talking the 25th of February.
Mm-hmm.
So we would change that, but otherwise...
From 18 to 25th, yeah?
That gives them their 14 days. Paragraph 2 deals with directions in anticipation of an application being made. And I think we're happy to accept that condition, if you like, or that contingency.
Mm-hmm.
And we would suggest that evidence in response be the 8th of April, which is 21 days. So this is B, evidence in reply, 22nd of April, which is 14 days. And then I think listing will have to be for the registry, but I think we would say a time estimate of a day.
Yeah, single day.
I think we would remove the on the date, because that would be for the registry to determine.
Right.
Point 3, paragraph 3 has been agreed, so that's the response to the request for information. Paragraph 4 is then the new wording, which your lordship has seen at page IB 63. That's the agreed wording as agreed between the claimant and the third defendant.
Right, yes.
And then in terms of the expert directions, there is a slight wrinkle difference between myself and Mr. Pluman. Essentially, it is said we say that the expert meeting and joint report should be at the end of the process. Mr. Pluman believes that it should be in the middle of the process. So you should have an initial report, then a meeting and joint report, and then a responsive report. So there's a sweep up, if you like, at the end. Every counsel, every litigator will have their own view and their own experience, and every judge will have their own view and their own experience as to what works. In my experience, having the meetings and the joint report at the end is more effective. If you then allow a supplementary or a responsive report after that meeting, to the extent that any consensus is reached at the meeting in the joint report, it will be undone. And indeed, to the extent that there are any differences identified in the report, it is those differences that will be then written up at some length in the responsive report. So in our submission, the more classical, the more orthodox structure should be adopted. That's to say, an initial report exchanged, a responsive report. So if there's any points that one party is
Mr. Reed, it's not about whether classical or orthodox model. I think you need to look at the specificity of this application, the nature of this kind of expert. We have the report prepared by a witness. We have most of the facts that prepared by Brime, and then those two experts would look at them, and like the flow of information is coming from mainly one side, you know what I mean? To the experts, it might be. I mean, I don't know. I can see myself leaning towards Brime approach, more or less. I said it's yeah. I think the expert could deal with them in both cases, but because of the flow of information, because of this pledge, made by Brime mainly, and the witness evidence of Mr. Sadr connected very strongly to this. Maybe meeting in the middle would.
I mean, I not.
If you are able to agree with Mr. Plusman, then that would cut short things.
Notwithstanding the eloquence of Mr. Pluman, the task of probing the ledger is more difficult than it may seem. Much of the narrative to the various items, so this money is in respect of this cargo, much of that narrative may be subject to challenge. And just as an order,
but tell me, even your position was much different before we reached to this point. I mean, now you there is a time now where you have changed your mind, and then you follow Mr. Pluman. So you didn't need to compromise again to follow Mr. Pluman. Sorry, the Brime. For second situation, why didn't you take their approach?
Well, Manu, we have changed. We've changed our mind because we've seen what is in Sadr. It's not. Our starting point has been simple. We agreed with your lordship's position in the case management judgment in September.
Mm-hmm.
Let's get disclosure. Let's look at the underlying documents. Then let's see. Well, actually, what we then had was that the analysis of the underlying documents put forward in Mr. Sadr as a lay witness, which was precisely what the third defendant said they weren't going to do, but what they then did. Then, seeing the complexity, we agreed that expert accountancy evidence was necessary. To the extent that your lordship may have been suggesting that the sort of directions we were proposing were overkill, or in my submission, we need both responsive reports and a meeting and joint reports. There's just a tiny difference as to whether the joint report and meeting come at the end or come in the middle of the process. I don't think we feel especially strongly. I simply ventilate my own experience that having that meeting and joint report at the end tends to be better. And to the extent that there is any consensus at that point, it's more likely to survive if you don't then have a further round of responsive experts reports.
I don't know, maybe the earlier the experts can meet, maybe the earlier the experts can do things together, maybe the earlier the experts can identify differences and disagreement is better, and that even will allow you to work from a better basis. I mean, if you just leave it to the end and then I don't know, we might come to surprise.
My Lord, the Chancery Standard Expert Directions of one of the divisions of the English High Court has an early meeting of experts and then a later meeting of experts. We're in your Lordship's hands as to what your Lordship thinks will work. We're not persuaded that.
But I think it's not a big deal. I would, but if unless you agreed, I would follow Mr. Blumen approach.
Well, okay. So we will. So experts. So point 5. I just need to cross-refer here. Point 5 is experts reports by the 25th of March. That is agreed.
I'm sorry. We had raised. I'm sorry to interrupt, but we had raised with Mr. Reid informally. These dates were all agreed on the basis that Prime were contending that the matter should come to trial in July, which has now proved to be, it appears, impossible. And it may be that if it's an October date, they should still be very well in advance of that, but that actually there is space to add a month or so to each of the dates to ensure that there is no slippage. And I can't see why one shouldn't do that. We had set out, if one needs to see the dates in our own draft order, they are also there, but I don't think we have to go there. I would simply suggest expert reports by the end of April, and then a meeting within a month thereof, and then the responsive reports within 2 weeks after that.
Well, I think that would meet your expectation, Mr. Reid. Is that right?
My Lord, yes. So experts reports by end of April, meeting by May, and joint, I presume, and meeting and joint reports by the end of May.
Yes.
Okay.
Yeah, this used and
then responsive reports end of June. And we can take the last Thursday of each of those months as the relevant date.
Yeah, we still do. We're 4 months away from the trial yet. Yes.
Okay, so if we use the final Thursday in each of those months as the reference date, just possibly make sure we don't hit any public holidays. So April would be the 29th of April for the reports.
But you're not bound by UAE public holidays, isn't it? You could work freely because, I don't know, I think you work from London dairies. Is that right?
We do. In theory, they're being filed. So yes. I suppose they're being electronically filed. So it may be that even a UAE public holiday doesn't. But I don't think there are. There are public holidays in the middle of May. But the Thursday, the 27th of May works.
I don't know. I remember most of the English holidays comes on Monday.
They do, the bank holidays. And then,
and things like that, yeah.
And then June would be the 24th of June.
Mm-hmm.
Yes, we're content with those dates.
Lovely.
So that's the expert evidence and the timetable for experts.
Then the progress monitoring date?
Progress monitoring date.
This is 4 weeks prior to trial, maybe?
So So that's Sunday the, sorry. Sunday the
What's the trial week we said now? What week?
The week
of October?
The 3rd and the 10th of October.
3rd to the 10th of October?
My lord, yes. And my lord, a month before that would be Sunday the 5th of September. And I suppose those are the...
I just want to open the calendar. If you give me a second, bear with me.
So Sunday the 5th of September would be a month before the trial starts. And then we have...
I have Sunday on 3rd for me.
Oh, you have Sunday the 3rd of September?
No, I said the week commenced 3rd of October.
My lord, yes. Are you...
And then the first 5 days. So the first 5 days is 3rd to the 7th. And then what is the proposed time? I mean, the length of the trial, is it?
Well,
are you serious about 7 days?
Well, my own feeling is would be 5 to 7.
Yeah. What we have previously without expert Robert, we said 3.5 days.
My lord, yes.
And then we can give 1 full day for the expert, and that's it. And then maybe another half day for whatever happened. So that shall make it 5 days, isn't it? We didn't need more than 5 days.
Well, my lord, our estimate would be 5 to 7. Mr. Pluman is at the upper end of that bracket, and I suspect if D1, D2 came in, we would require at least 2.
So really, if we look at the issues in this case, we need issue to the number of, let's say, disagreement need to be decided in this case. I mean, the question need to be answered by the court in this case are relatively shortened. I mean, I know fraud usually, complex in nature, but it's not about this. It's about the numbers of issues involved, the number of findings that the court need to know, and the number of legal questions involved. The complexity is that. I mean, if we're going to talk about fraud for 5-6 days, I mean, yeah, we could talk about it for 30 days, but I don't think in my assessment we will need. Even if Renish come on record for the trial, I will still think 5 days is a reasonable date for that.
Lord, if I may just express Prime's position on that. Our concern is that we should not be conservative about the trial length as a matter of arrangement at this stage. We can always reduce it later, and the parties perhaps should be obliged to keep the estimates of the trial length under review. But what we, again, are very anxious to avoid is a situation where we get to October and then there isn't enough time to finish the trial and we can't achieve finality. Prime's position is it's an innocent party, it claims, that's our case, and wishes to be freed of the WFO. So we would ask your lordship to allow 7 days, but we would be entirely content that your lordship require the parties to reassess the trial duration after the expert meeting process has taken place, at which stage we may have a much better view of how wide or narrow the points of dispute are.
Or maybe we could, in the pre-trial monitoring date, so in that time we could come up with a trial timetable, and that would give us a better indication with the exact length we need. So the court can vacate the rest of the 2 days. Is that right?
Exactly so, my lord. We'd be entirely content with that.
My lord, that would be our preferred date too. By that stage, we'll pretty much have a trial bundle. We'll have seen the experts' reports, the joint report, and the witness statements, and the council will have mapped out their cross-examination. So,
and yeah, we will be definite about even a Renish position by then. Yeah.
But in my submission, whilst D1 and D2 is still threatening, intimating, and we should keep both 2 weeks penciled in, and until the progress monitoring date, it would make sense reserving seven days.
Yes, and the other point, my lord, you may have seen this, that Mr. Sader has said in his witness statement, which is given in English because there wasn't time to translate it, but his first language is Farsi and wishes to give evidence in Farsi, and so the process of giving evidence with interpreters may also be slightly slower than it would otherwise be.
Well, I see. Well, the evidence of Mr. Stader is like something would be dealt with by the experts. So why do we need to spend more time in cross-examining Mr. Stader about maybe about the source of information sometimes, maybe about a possibility of forgery or something like that?
Yes, that of course is true, although it's a matter for Mr. Reid as to what extent he will want to cross-examine Mr. Sader. But again, it's the sort of thing where it's better that we allow for it now, but then at the progress monitoring date, if it is clear that the scope for factual cross-examination is quite limited, we can reduce the trial allocation and free up the time for the court.
Obviously, to the extent that there's a fraud, the relevant guilty intention will be that of Mr. Farhang or Mr. Sader. So that will be important cross-examination, and it will no doubt take some time in terms of building that cross-examination.
Yeah, let's engage Mr. Duckworth with us, because there is one possibility that Mr. Duckworth, the client, would come up to trial, and on that basis, what's your imagination about the length of the trial, Mr. Duckworth?
Well, I'm strictly a spectator at this point, but
I'm very optimistic about your client coming up to trial. You see, that's what I'm fighting.
On the assumption that my clients come to trial, I don't see it lasting less than 5 days, and I have grave doubts whether it would even fit into 7 days. But 7 days would seem to be a reasonable time estimate to allow for those possibilities.
So we need to reserve 2 weeks, the possibility of 5 to 7, with another smaller possibility that it could go more than 7 days. I'll try to accommodate this with the registry and see how we're going to do it.
Great.
Thank you, Lord. That'd be very helpful.
My Lord, in respect of the rest of the items, we have reading list, which is 2 clear days, skeleton, which is 3 clear days before trial. So if it starts on a Sunday, that's to say it's 4 p.m. on the Monday before. So that is essentially gives almost a week for the parties and the court to touch the skeletons. Chronology, 3 clear days before trial. I don't understand there to be any significant difference between the active parties on that. And then we've dealt with the trial.
See, if we have this long stretch, I mean, timetable, why the skeletons comes like 3 clear days only? Why it's not 5 days, for example? But that would give us a better preparation, better management for the trial timetable, maybe.
Well,
Yes, we'd be content with that.
Yeah. I don't think we'd resist that. Yes, I mean it's a question of if you want.
Because I'll tell you, I'll be honest with you, because the direct 2 days before the trial for us here, it's a weekend. If you give it to me, like say 3 days, probably I have only Thursday, and that would you engage me and read busy with the case and the rest of my weekend before I start. I mean, dealing with the case. You know what I mean?
My Lord, yes. So
that better me or any other judge. I mean, we know exactly who's going to be the trial judge. But the probabilities, it's myself, but it could be someone else. Yeah.
Well, my lord, I wonder if you could say the Sunday before the 3rd.
I'll say either Sunday or even Monday.
Okay.
End of Monday, doesn't matter, Mister.
My lord, if we said Monday the 27th.
But if you give the judge like the last 3 days of that week, let's say Tuesday, Wednesday, and Thursday, having the skeleton in his hand, so he'd be prepared without even like jeopardizing his weekend. Because the way we work is a bit different because we're full-time judges. We have our holiday. We work in different formula than the way you work, Mr. Reid.
I understand. So
if I work weekend, there is no what's so called extra payment for judge working at the weekends. So my weekend does not count. So just don't put the judges in trouble.
Well, my lord, if we said 4 p.m. on Monday the 27th of September for the
that's reasonable, yes.
Right. And then trial we've discussed, the 7-day time estimate discussed, and costs of the CFI in the case.
Right. That's right. That's really good.
Well, my lord, I think we've covered everything.
Yeah, I guess so. Yes, I guess so.
My lord,
anything you wish?
Two matters I would like to raise, if I may.
Yes,
they're quite important to us. They relate to the allegation of forgery. I wonder if I can just set the background. If I could ask you to turn to paragraph 38 of your immediate judgment, my lord, at page H41. That's in tab 13.
Yes, and you're what paragraph?
Paragraph 38. I could just briefly read it. It's common ground between Prime and SBM that the purported transaction for which at least a substantial part of the sums advanced by SBM to Prime, the purported supply of oil by Prime to Lanka, was never intended or agreed by Prime. Accordingly, the irresistible inference is that Mr. Ahmed, Mr. Mehta, knowingly deceived SBM when it was represented to SBM that monies were required pursuant to contract with Lanka. It can similarly be inferred that trade documents provided to SBM, including the relevant back-to-back contracts made by Renish with each of Prime as supplier and Lanka as end purchaser on the relevant headed paper, were forged. This was the case advanced to your lordship at the immediate judgment hearing by my learned friend Mr. Reid.
Right.
Subsequent disclosures and inquiries, including a document disclosed yesterday, very late in the day, show that this allegation can't possibly be correct. In this connection, I invite you to look at the correspondence at IB 75, tab 6.
No, sorry, but are you bringing this to the court attention in what basis now, Mr. Dawar? We have granted you 14 days to come up with that application.
Yes.
If you think your case is strong, you could set aside that, all of the allegations.
My lord, the reason I raise it at this point, and I hope it's not premature, is that it dictates the way in which we present our application, and in the sort of expert evidence we need to be thinking about now rather than later in the day. I propose to show your lordship, or maybe we can take it as read, that in fact the Lanka contracts were all genuine. There's no evidence of forgery of those documents, and indeed there's very, very thin evidence that any other document was forged, and considerable evidence that all of the documents in this case were valid trade transactions. So I need the claimant to tell your lordship and us as soon as possible, and we say why not do it now or within 7 days of today, whether they are relying on the allegation that documents were forged, because that materially alters the progress of the case. If there are forged documents, then, as it was the case in the Fujairah Bank trial, which I believe is a spin-off from this litigation, we need experts to consider the documentation to validate whether they are forged or not. And we need to be thinking about that now. We don't want to to think about that at the close of pleadings on the set-aside application. So that's why I might.
Well, I tell you how it's going to work. I mean, we didn't need to go that far, Mr. Duckworth. I mean, you're an expert in this kind of proceeding. And it's in a set aside, you didn't need to go far and you to prove completely against this. So I think the level of that you need to convince the court that you have a better case than it's been pleaded against you. That will allow you to go against all the allegations said. If this evidence before us, if this evidence discussed during the application in depth, then that would be even before the experts that appointed. If it's very strong evidence you have, you would, I mean, defeat this allegation completely, and then you would verse the pictures against this transaction. And if it's a single transaction, and if you could prove it, maybe we didn't need to go that far to appoint an expert to tell us whether this is genuine or not. Maybe by yourself, by your evidence, by your supporting document, you could prove before the court this is a genuine. And this would be anyway before the claimant before Prime, and the expert would have access to this kind of information, or it would become evidence at later stage. But yeah, that is my assessment. I mean, let's hear from the other parties what they want to say about it.
Could I just add one thing to what I said?
Okay, finish first, then I will refer.
Yes, that it was Dentons themselves who disclosed correspondence with IOC Lanka yesterday that demonstrates beyond all possible doubt that the Lanka contracts were not forged. They are genuine trading documents. And that's why I invite Mr. Reid here and now to concede that point, rather than us having to deal with it in pleadings.
What to consider, but I said no point. We're just looking at the case management, which we just finished for now, and this is something for the progress of the application that you want to bring. You were about to bring, Mr. Duckworth. But anyway, I would allow for short comments by both Prime and by SPM.
My Lord,
Mr. Reid,
can I just explain the point? We've been making inquiries for some time of Lanka, trying to get to the bottom of this. Finally, about a week ago, we received an email which suggested that they hadn't received the oil for the last 3 cargoes, but that they say the contracts, they were genuine, they were real contracts. Now, we are pressing them on that. We're not going to make any concessions, whether pursuant to any challenge of the CMC or otherwise. We've asked for the documentation. We hope that Lanka will provide it. When we see the evidence, the documentation, we will take a view. But we felt that it was proper in discharging our professional duties to waive litigation privilege, which undoubtedly covers our inquiries of Lanka, in order that it could not be suggested that we have in any way misled the court. That evidence is there. It's for Mr. Duckworth to consider in respect of his application. It's for him to make his case, and if he feels necessary, to plead his case and to decide how he wishes to evidence his case. But no, we're not responding to challenges in that way, or prefiguring our evidence, or disclaiming parts of
yeah, I don't think it's the right time to do so.
Straight with the court, and not wishing to mislead anyone, and seeking to discharge our professional and ethical duties.
Yes, my Lord, we agree with that. Of course, the position is that Prime does not say, and has never said, that the contracts with Lanka were forged. What Prime says is that what Renish put up as a contract with Prime was not a contract with Prime, and that's what the factual evidence deals with. The payments that Prime received were payments from Renish. It didn't receive payments from SPM. It says it has a valid defense to all of these things. Insofar as Mr. Duckworth now says he wants to bring a case on some basis that the contracts were genuine, well, if and when they are allowed into the case, no doubt that is the defense that he's going to put up. But he's resisted getting on with directions in the interim. We will respond in due course as and when there's a pleading to respond to.
Is that clear, Mr. Duckworth, for you? I think that all matters would be dealt with in your application.
Yes, I merely wish to assist the court by inserting a direction that didn't slow down the timetable, that we could actually make some progress on this here and now. If my learned friends think that it doesn't prejudice progress of the case, well, I dare say that my application is less forceful, albeit I still maintain it.
Well, thank you very much, Mr. Duckworth, for bringing this to the court's attention. We will deal with it in the due course once it's before the court officially in your application, and the parties will respond to it again formally and officially. So what's left is just to thank you for collaboration, for having a progressed case management. I'm looking forward to hear from Mr. Duckworth first and to finish this case within this year. All the best for all of you.
Thank you.
Thank you very much.
Thank you very much.
Mr. Reid, I would wait for the draft from your side. Is that right?
We will pass it on to you, the other parties.
Thank you very much.
Thank you. Thank you, everyone.
Good morning.